Salam sejahtera to Profesor Madya Dr. Haji Muhammad Shanawi bin Muhammad Pirus. I am Definition dan Anak Dennis Chungat with student number 2024520023. Today, I'll be presenting a landmark case in the intersection of cybersecurity, employment law, and privacy. Toh Si Wei versus Teddric John Mohr and Anor for Assignment 2. Cases of law on cybersecurity in accordance with the requirement of the subject, Industrial Relations, Regulations, and Cybersecurity INC500. Today, I will elaborate on facts of the case, issue of the case, judgment of the case, plus analysis and critique. This case isn't just a legal dispute. It represents the modern tension between corporate misconduct and digital privacy. Our plaintiff, Toh Si Wei, was the Chief Operating Officer of Penang Adventist Hospital. The defendants were his superior, the CEO, Teddric John Mohr, and the VP of Medical Affairs. The conflict began when the plaintiff was summarily dismissed after the defendant obtained printouts of his private Hotmail account. This email allegedly contained injurious remarks about the hospital administration and evidence of conspiracy to remove the CEO. The plaintiff alleged his account was hacked while he was overseas. Conversely, the defendant claimed they received the email anonymously in an unmarked envelope. Seeking justice, the plaintiff sued for invasion of privacy and breach of confidence, seeking 2 million ringgit in damages. The court have to resolve four fundamental questions that define our digital boundaries. This is where the legal complexity begins. 1. The tort of privacy. The court has to ask, does Malaysian law recognize a freestanding invasion privacy right between private individuals? This is crucial because while we feel we have privacy, the court has to decide if you can legally sue a private party like your boss for it, or if that right is only protected against the state. Second, breach of confidence. Did the retrieval of these private emails constitute a breach of duty of confidence? The court have to determine if an email remains confidential if its contents involve plotting against the very organization you work for. Third, burden of proof for hacking. Under the Computer Crime Act 1997, did the plaintiff provide enough evidence to prove the defendant were the one who hacked him? This set a high bar for digital evidence. Is simply having a printout enough to prove you were the thief? And fourth, public interest versus personal privacy. Finally, does a hospital rights to know about internal iniquity or wrongdoing outweigh an employee's rights to email privacy? This is a massive question for industrial relations. Can tainted evidence be used if it protects the company's integrity? Now we move to the most critical part of the presentation, the High Court's decision. The judge dismissed the plaintiff claim based on five key legal pillars. I will go through this one by one as they define the rules of engagement for digital evidence in Malaysia today. Failure to prove the hacking. This first point is about the Computer Crimes 1997. The plaintiff was adamant that he was hacked. However, the court ruled that he failed to provide the defendant were the perpetrator. This is a vital lesson for us. In civil court, suspicion is not proof. Even though the defendant possessed the email, the plaintiff couldn't provide the forensic smoking gun to link them in the act of hacking. Second, loss of confidence through third-party disclosure. This second point involved the breach of confidence. The judge noted that the plaintiff has sent this email to third-party friends. Under Malaysian law, for information to be protected as confidential, it must have the quality of confidence. By hitting send and sharing those thoughts to outsiders, the plaintiff effectively published the info. Once the information is in public domain, you can no longer claim it is a secret. Privacy is limited to modesty. So this third point, whereby the court addressed the tort of privacy. This is perhaps the most controversial part of the judgment. The judge ruled that in Malaysia, the right to privacy is currently restricted to the case of physical modesty. For example, if someone were filmed in a changing room, the law would protect them. But informational privacy, like the data in your Hotmail inbox, does not yet receive the same level of protection under Malaysian tort law. Fourth, the doctrine of unclean hand. Here, we have the equitable principle. The plaintiff was asking the court for equity, which is fairness. However, a foundational rule of law that he who comes to equity must come with clean hands. Because the plaintiff was using his emails to circulate injurious and defamatory remarks about his employer, the court found his hands were unclean. He was essentially using his privacy as shield for his own misconduct, and the court refused to allow it. And lastly, the iniquity rule. The final point is that the public interest exception. The judge famously stated there is no confidence as to the disclosure of the iniquity. This means the confidentiality cannot be used as a mask to hide a wrongdoing. Because the email contained evidence of a conspiracy against the hospital leadership, the court decided that the hospital's right to protect its own integrity outweighed the plaintiff's right to email's privacy. Now, let's analyze the deeper legal implication of this ruling, the public interest privilege. This is the most significant takeaway for industrial relations. The court established that a hospital or any organization has a public interest right to discover wrongdoing. If an employee is a plan if an employee is planning a corporate coup, the court will almost always side with the organization's right to protect its integrity over the individual's right to hide those messages. Second, the equity of industrial relation. The unclean hand doctrine used here reinforce that the relationship between employer and employee is built on fidelity. When the plaintiff breached that fidelity by disparaging his superior, he lost the moral ground required to win the lawsuit in court of equity. And third, the high burden for cyber evidence. This case highlights a major hurdle in cybersecurity litigation. Under Evidence Act 1950, the burden was on the plaintiff to provide a forensic link. Without a digital trail or an IP log proving that the defendants entered the account, a printout is simply not enough to secure a conviction or civil win for hacking. While the judgment is legally sound based on the current rules, it leaves us with four major concerns or critiques. The first critique, the private vacuum. Malaysia lacks a specific privacy act for individual citizens like you and me. This forced the court to squeeze a modern digital issue into a breach of confidence framework. But emails aren't trade secret, they are personal. We need laws that recognize this personal data as its own category of protection. And then the second critique, restrictive recognition of tort. The judge was hesitant to expand the tort of invasion of privacy beyond physical modesty. By excluding informational privacy, the court have essentially left every employee in Malaysia vulnerable to the surreptitious monitoring. As long as the boss can claim it's in the public interest to watch them, they will continue to monitor our emails or any information about us. And then the third critic, the constitutional limitation. The court ruled that Article 5, the rights to privacy, does not have the horizontal effect, meaning it does not apply between two private citizens. This actually creates a massive hurdle for victims of high-tech harassment or private hacking. If you can't invoke your constitutional liberties, your path to justice is much harder. And the fourth critic, evolution of law. Finally, even with the Cybersecurity Act 2024, our focus remains on the national infrastructure. We still do not have a clear modern civil remedy for a regular person whose private life is breached. Until our laws catch up with our technologies, the anonymous envelope excuse will continue to be a loophole for employers. In summary, this case serves a warning for the digital age. Your private emails, my private emails, may lose its legal protection if they involve professional misconduct. Thank you for your time.